I'm Dennis O'Connor. I retired about a year and a half ago as the chief consultant to the Senate Natural Resources and Water Committee, and PCL asked me to moderate this panel. Before we get started, by a show of hands, how many of you all are students? Wow. Cool. And how many are attorneys? Okay, and then the rest of us, water wonks? Okay, it's good to know who we're talking to. I think it's safe to say that nobody would design a water rights system the way California has on purpose. We've got a variety of different rights, each with their own idiosyncrasies. We've got riparian rights, pre-14 appropriative rights, post-14 appropriative rights, Pueblo rights, Federal Reserve rights, and that's just on the surface water side. In the groundwater, we have overlying rights, appropriative rights, prescriptive rights, and Federal Reserve rights over there. We have a number of different institutions designed to manage various aspects of water rights, each with varying levels of effectiveness. We've got the State Water Resources Control Board, we have groundwater sustainability agencies, DWR, the Department of Water Resources, Department of Fish and Wildlife has a role, and of course the courts. We have a variety of constitutional, statutory, and common law requisites. Number one being that under our Article 10, Section 2, that all water be put to a reasonable and beneficial use. We have the public trust doctrine under the Audubon decision. We have in the statutes that the highest official policy of the state is that water for domestic purposes is the highest in use, and that the next highest is for irrigation. We have the human right to water. That is the established policy of the state that every human being has the right to safe, clean, affordable, and accessible water. We have policies regarding encouraging water transfers. We've got a new one that potable water to irrigate non-functional turf is wasteful and incompatible with the state's policy relating to climate change. I could go on. And yet, despite all of this stuff, we have numerous examples of problems regarding the assignment, administration, and use of these rights. We have unfulfilled policies. The human right to water, clearly not there yet. Sustainable groundwater, clearly not there yet. We have suboptimal administration of our water rights. The pre-14s, we have issues with curtailment orders and ineffective penalties. Inadequate protection of public trust resources, such as the various salmon and steelhead runs, or the ongoing challenges at Mono Lake. We have allocation of water rights reflecting late 19th century and earliest 20th century priorities in a 21st century world. In some parts of the state, the distribution of water among urban, ag, and environmental uses seems skewed. And we have the dark and violent historic underpinnings of pre-1914 water rights in California, described in an amicus brief filed by the Winnemucca Wind 2, Shingle Springs Bandit Miwok, Little Manila Rising, and Restore the Delta in the California curtailment cases. Toss in climate change and the associated changes in hydrology, and it's clear that California's current system of water rights needs some attention. As noted in the conference description for this session, 1 million Californians do not have safe drinking water. California's aquatic systems are in crisis, and users are confronting increasingly scarce and unpredictable water supplies. This session in the legislature has shown an unusual interest in improving various aspects of our water rights system, a number of which have already been signed into law. We have AB 779 by Wilson, which makes changes regarding the adjudication process to take into consideration the needs of disadvantaged communities. I mentioned the prohibition on potable water to irrigate non-functional turf in commercial, municipal, and institutional entities. There was a comment in the prior panel about the diversion of flood flows for groundwater recharge. And then Senator Allen, who should be here shortly, had a bill that authorizes the State Water Resources Control Board to issue an informational order to ascertain whether any claimed right is valid, including 314 and riparian rights. And there's still a whole bunch that are still pending, most notably AB 460 by Assemblymember Bauer Gahan, which grants the state board the authority to issue an interim relief order, and AB 1337 by Assemblymember Wicks, which authorizes the state board to issue curtailment orders to pre-14s. Let's see. So I guess the question is, before we make all these other changes, and here he is himself, Senator Allen, how do we address and correct all these issues while dealing with the historic problems of inequities associated with colonialism, genocide, patriarchy, and continued discrepancies of wealth and power, per the PCL thing? So that's what we're going to talk about, is how do we improve our water rights system and at the same time make progress on these various legacy issues. Today we have with us, Crystal Moreno, the Director of Traditional Ecological Knowledge Department with the Shingle Springs Band of Miwok Indians. We have Dave Owen, the Harry D. Sunderland Professor and Associate Dean for Research at UC La San Francisco. We're almost in the order that I typed this in. We have Tien Tran, the Senior Policy Advocate for the Community Water Center. Natalie Escobedo Garcia, which is a Water Policy Coordinator for the Leadership Council for Justice and Accountability. And a special aid addition, Senator Ben Allen, who represents the 24th Senatorial District. So here's how this panel's going to work. After I finish this intro, David, Crystal, Natalie, and Tien will each get about 7 minutes to sort of lay out their perspective on the issues. Then for the next 30 minutes or so, I'll ask the panelists a series of questions that are intended to further explore the issues they raised, and perhaps some of them that they did not. We will then have about 15 minutes for the audience to ask questions, and then we'll give Senator Allen about 15 minutes to act as a one-person response panel to all of this. This way you didn't have to study ahead of time. And then finally we'll close with giving everybody a final statement before we close. But before we begin, Senator Allen wanted to make a brief opening comment, according to your staff.
I'm very pleased to be here. Looking forward to the discussion.
Okay. I'll talk to them. Okay, so why don't we start with Crystal?
Good morning, everybody. I'm Crystal Moreno. I'm here on behalf of the Vice Chair of the Shingle Springs Band of Miwok Indians. I want to provide a very short background on the tribe. Our name is the Shingle Springs Band of Miwok Indians. However, because of what happened to Native people in the state, the tribe's ancestral territory spans 7 California counties, although the tribe is currently located in Shingle Springs. Having said that, we found that it was necessary to start getting involved and engaged in water advocacy, particularly around tribal water rights and the protection of our waterways. Our waterways are, obviously connected to what we refer to as our tribal cultural landscapes. The significance there is that everything is connected. And the work that we do under traditional ecological knowledge, we not only utilize our cultural knowledge and pass it down, but we also pass down our knowledge and our experience with advocating for things that need to be protected, particularly when it impacts culture. If the Vice Chair was here today, and she sent her regards that she could not be here, she's a much more eloquent and passionate speaker than I am, but if she was here, she would tell you culture is ecology and ecology is culture. Everything is connected. That's our approach to water. We've all heard water is life, and it can't get even more clear than that. That's just the truth. Without water quality standards set for things like tribal beneficial uses, tribes are at a higher disadvantage because of our exposure rates to water. So we believe without tribal beneficial uses being protected, which can happen at the water board level, We're also potentially looking to run state legislation to address the issue. We feel that our tribal communities are at greater risk. We also use the water recreationally, but on top of that, we're in the waterways, we're gathering our traditional medicinal plants, we're conducting ceremonies, we are out there teaching cultural activities. And there are times, there have been a few, even just this past year, where we were not able to do so because the water quality was so poor in and around the areas that we consider ancestral territory. So having said all that, we have a major challenge as just in the inherent racist water rights structure, right? So tribes were left out of the conversations from the very beginning. But if we want to talk about first in time, first in right, this is where we start, right? So what we've been doing is really trying to work within, state and federal agency structures, trying to get our voices heard, because like I said, for so long, and even today, we are left out of conversations of decision making because we don't have, many of us do not have water rights. Those of us that do came across water rights because we were able to purchase or reattain ancestral homelands, and there were rights that were attached to the land purchases. But not every tribe in California is able to do that. Many of us are under-resourced, especially the tribes that have not been recognized by the federal government, which I won't get into. So what we've done is we've pulled together a coalition of tribes and also environmental justice groups. And through that work, through this advocacy work, we have been able to get to the table. We've been able to, I believe, move the needle a little bit. And that happened because we filed a petition for rulemaking against the State Water Board, or with the State Water Board, to compel them to update the Bay Delta plan, which had not been updated in 2 decades, maybe even more. And because it had not been updated in so many years, our water quality standards have not been adequately adjusted. The plan does not include protection of tribal beneficial uses, so we've been advocating with the board to make sure that TBUs are included. We haven't received any signal from them that they're willing to do that. The staff made a recommendation. Actually, the staff did not recommend. The staff mentioned it was a possibility, but did not say we strongly recommend inclusion of TBUs in the updated Bay Delta plan. Having said that, we pushed it even further. We took our concerns to US EPA. We filed a Title VI complaint, and that actually took. So US EPA accepted our petition. They are investigating the State Water Resources Control Board's actions or lack of actions, and we're currently undergoing that process. TBUs, we're talking about tribal water rights. TBUs is a good place to start, right? Because we understand it's going to take time to restructure the current water rights system. It's low-hanging fruit. We don't understand the reluctance of the State Water Board to implement on a statewide, watershed-wide basis. They've kicked that responsibility to the regional boards, and this process has taken years. The TBU definitions were adopted by the State Water Board in 2017. We are now in 2024, and the regional boards just adopted definitions that have already been adopted at the statewide level. We really feel like this process has just been, dragging along. We feel like, it's important, as does the US EPA feels like it's important. And in fact, they released comments to the State Water Board and said TBUs should be done expeditiously. So we're going to jump on that. We're going to utilize that, and hopefully we'll be introducing legislation to address TBUs being implemented, designated, adopted at the statewide level on a watershed-wide basis.
Dennis, I was a little flippant, I suppose, when you first turned to me, and I really appreciate Ms. Marina's comments, because I think part of what my staff wanted us to do was just to frame some of the conversation in the context of the big success that we had this year with SB 389. Ms. Marina spoke about water rights, and I'm very interested in hearing about the legislation you're thinking about. But we've had so little progress on the topic of water rights for so long. And yes, it's so the status quo is so grounded in a lot of the bad things that you laid out: colonialism, displacement of Native peoples, patriarchy, continued discrepancies of wealth and power, and of course, wealth and power work hard to maintain wealth and power and status quo, and so you get this whole machine in Sacramento that kicks into gear to defend the status quo and the governing system. It makes it really hard for us to have the kinds of conversations that we know we need to have, and we're going to be having here today. Thankfully, I guess the situation's gotten so bad. I mean, I don't say that thankfully, but it's forced a real conversation in Sacramento. You know, climate change, the impacts of drought, the lowering of our water table has forced conversations about water rights that we hadn't been able to have before because of the politics. And several ambitious bills were proposed over the course of the past couple of years. And I do want to tip my hat especially to my colleagues Buffy Wicks and Rebecca Bauer-Kahan, who proposed AB 460 and AB 1337. Our bill was part of a package, SB 389. Unfortunately, ours was the only one that got across the finish line this last year. And we did it in very close coordination with PCL. I see Dylan and Tina from my staff here who worked really hard on this bill. But it basically gets to this question of a first in time, first in right. You have all of these pre-1914 water rights that exist back when California truly was the wild, wild west, and people were showing up in the Central Valley with a piece of paper, nailing it on a tree and saying, I declare that all the water in this area is mine. Of course, it was always, talking about equity issues, it was always white guys, right, let's be honest, who were just walking on other folks' land oftentimes and declaring the water right to themselves. And those water rights have accrued enormous wealth and power. That's been the lifeblood of the valley. It's what's fed the agricultural industry, and of course it's also fed a lot of wealth as they sell those rights to cities, to the growing cities, and so when we proposed this bill, we actually got a lot of consternation from cities because they were really stressed out about what this might mean to their access to water. But basically, all the bill did ultimately, it wasn't that radical. It was amazing how much pushback we got. But it basically gave the water board the right to investigate and ascertain whether a water right is valid. The rules up until we got this thing passed said that anything pre-1914, it's a closed book. You can't ask questions. It's just grandfathered in. If anyone could show, just on a preponderance of the evidence standard, that there was some validity to the right, they were going to be fine. But we did want to, given the fact that we've got something like 3 times as many water rights as we have water in the state of California, we need to start getting real about the solvency and the sustainability of our system. And it's part of why we're trying to give the water board more tools to govern the system, to actually do the job that we are tasked it with, which is to ensure the sustainability and equity and workability of our water system. Now, of course, sometimes they don't do enough, even with the tools they have, which I think Ms. Moreno did a great job of articulating. It's probably why we need to spend more time looking particularly at the question of tribal water rights as it relates to the water board. But there's whole areas where we have unnecessarily tied their hands. And that's what we're trying to get at here. That's why I'm so proud that we got 389 across the finish line. And I'm really hopeful that it will be the first in a long string of legislation that will reshift the conversation so that we can get, we can create a water rights system for the future that will make California much more resilient given the climate change that we know is already happening. And so that's some of the work that we've been doing in the legislature. There's a lot more to do, and appreciate Ms. Moreno's comments and very much looking forward to the other panelists' comments.
And speaking of other panelists' comments, we have Dave Owens.
Okay, so thank you, Dennis. Thank you for inviting me to join this panel. I'm just going to say a few words about a few ideas of things that could be done. The first few are going to focus on the functionality of the water rights system, the same issues that Senator Allen was just talking about. And then I'm going to talk about something that may be a little bit more ambitious and far-reaching and longer term that goes to more management of groundwater rights and governance of water in California more generally. So a lot of the stuff that I'm going to say draws on a report that came out of Berkeley Law, the Center for the Law of Energy and the Environment, along with Jennifer Harder, who I see in the audience, who's also an author on this, as I was. And so this came out last year. Some of you may have heard about it already. I think it's still pretty relevant to some of the issues that Senator Allen was talking about a moment ago and to some of the ideas going forward. So this is a very quick summary of some of the things that we, and of course many other people, have found about the existing water rights system. We have huge problems with information gaps. The board doesn't have the information that it needs. The information it gets, it can't always trust, or often can't trust. Enforcement authority, a lot of us think it's there in the water code and in the California Constitution, but there's enough ambiguity that the board isn't always certain about what it can do. Very cumbersome enforcement mechanisms, and I'll give you an example of that in a moment, and in some situations very weak penalties. And so this combination means that what looks like a fairly orderly system, if you just look at the underlying rules for allocating water, in practice turns out sometimes to be something very different. Not always. There are areas where we have very good information and good records and good enforcement, but it's very uneven. I'm going to give you an example of that. This is a chart that Nell Green Island at Berkeley Law put together that I think is a work of art in how much it captures some of the problems with our water system. So I'm going to start on the far right. You can see a vertical orange bar there. This is showing flows and then diversions on the Shasta River. And that vertical orange bar is showing an episode that probably many people in this room heard about, where the Shasta River Water Users Association just illegally took water over a period of about, I believe it was 10 or 12 days. Nell will correct me on that after the fact, if I get the number wrong. And this got headlines, this got news, this was really a scandal, as it should have been. I mean, they openly flouted the law. The state board told them, please stop. They said no. And then they just kept going until they reached the point where the statutory penalties would have risen to a level that they might actually care about. So that was a scandal. Look a year earlier, and what you're seeing in that yellow zone is a long period of time when the gap between the flow that for biological reasons should have been in the river as a minimum flow, and the gap and the amount that was actually flowing in the river was the same as it was during that relatively short period of illegal diversions the next year. Why is that entire gap there? It is there because the board can't put emergency restrictions in place until it either has enough of a drought elapsed or a gubernatorial declaration. It didn't have either of those things. And so this, I think, is just one example of the ways in which we have a very cumbersome enforcement mechanism and limited regulatory authority for the board that makes it very hard for it to enforce the water rights system in a timely way. Okay, so what can we do about all of this? In the report, we have a whole long list of reforms. I'm not going to give you all 10. I'm going to mercifully just give you 7. But there are a bunch of different things that we can do here. So one is to extend emergency rulemaking authority to all critically dry years. We don't have that ability right now. Another is to not just authorize and fund, but also require the State Water Board to engage in general rulemakings to basically predefine drought response plans, so they aren't invented anew each time we have a drought. Clarify the board's authority to address any diverters curtailment violations. Some diverters, especially pre-1914s and riparians, argue that the board doesn't have this authority. I think that argument always was wrong, but it would be nice to have the authority be clearer. Providing stronger penalty options for violations. Expressly authorizing board staff to physically go and shut the head gates if somebody is violating a water right. In other Western states, regulators have this authority. In California, we don't. Requiring more frequent and more accurate reporting of water use is also, I think, crucially important. And then finally, accelerating, and again, funding, because this is not cheap, the faster development of in-stream flow standards. We don't have that baseline flow requirement to compare with, at least a quantified requirement in a lot of California waterways. So, thankfully, the legislature has taken steps on some of these issues, or at least is working on them. Again, credit for all of these slides so far pretty much goes to Nell, who put these together. So here you can see a chart showing what SB 389, which passed last year, did, and what AB 460 and AB 1337 would do. And you can see that they're covering some of the issues that we are addressing in the report. And I think that is incredibly important. Addressing some issues is much, much better than addressing no issues. But you can also see that there are going to need to be more bills. There is more work still to be done. All right, I'm going to finish by shifting and talking about a different subject, which is groundwater governance. But really, this is a broader issue. This is about water governance in California more generally. And it is about the institutions that we give authority to govern water at local levels and ways in which they might be reformed. In other words, it's a third rail, but I'm going to go there anyway. The specific example I'm going to focus on is groundwater sustainability agencies. And as we all know, they are making incredibly important and I think wrenchingly difficult. I mean, you've heard this from the last panel as well. These are hard choices that groundwater sustainability agencies are going to have to make. And choices with really difficult implications for a lot of people's lives. Most of those GSAs are governed partly or entirely by water districts. And I'm using water district as an umbrella term here to refer to irrigation districts, California water districts, reclamation districts. There's lots of different varieties out there. Many of those water districts are dominated by landowners, and I don't just mean as a sort of matter of practical politics, I mean as a matter of law. In an irrigation district, you can't serve on the board unless you're a landowner. In a California water district, you can't vote for the board or serve on the board unless you are a landowner. There are some exceptions both ways, but those rules of thumb generally hold. And of course, this isn't unique to California. This is how water district governance is done around a lot of the West. And so those are the basic rules. And obviously, if you're a renter, if you are a mobile homeowner, you own your mobile home, but you don't own the land beneath it, there are a lot of situations where you may have a well, or you may be dependent on a well, or dependent on the water levels in your area, but you don't have control. Even if you live in a city, and you do have a vote for the city, but the water levels are determined largely by the pumping going around you, you don't have control. And so, one of the things for a research project I've been doing recently has been to try to map this, and to try to look at the composition of GSA governing boards, and see how democratic they really are. And so this is the result of some of the work that I've been doing. There's a whiz kid Berkeley undergrad named Ben who actually put together this map. And what we're mapping here is basically how democratic the governance structures of GSAs are, with an entity or a voting seat held by an entity that does not allow landowner voting, or excuse me, that has landowner voting and doesn't allow non-landowners to serve on the board, that gets a 1. Something that allows anybody to run if you're a citizen, and anybody to vote, that gets a 10. The averages are somewhere in between. And the main point here is that you can see that a lot of California's GSAs score pretty low on this. I mean, I think in an ideal world, this would all be dark blue. These would all be structures at least as democratic as counties or cities. And it's not, in fact, it's not even close. And so I think this is something also that the legislature can think about reforming, and reforming in a lot of ways. So one option, and again, couldn't do this overnight, because there's already so much work being done by these entities, you don't want to throw all of that away, but still, over the long term, you could limit groundwater governance to democratically elected bodies. You could do what other states have done and consolidate groundwater governance into larger geographic areas, perhaps with more of a hydrologic logic to them, and have those, again, be democratically governed entities. You could at least limit the eligibility of these non-democratic entities or semi-democratic entities for state and federal grant funding. I think that would be a powerful incentive to open up greater participation and greater rights. Limit eligibility for other governmental benefits, and perhaps even where there's hostility to allowing any of these things to happen, allow for a partial or even complete state takeover, where the state actually takes control of a water district that is not working with the state on achieving these important state priorities. I think these things would all create powerful incentives or genuinely more democratic governance systems for our water systems. Not going to solve all the problems, they're still going to be wrenching, but at least we could do it in a somewhat more democratic way. Thank you.
Jen, you want to go next?
Yes.
My slides are mostly pictures because I like pictures. everyone, my name is Tian Tran. I am a senior policy advocate at Community Water Center. I started back in May 2022 and jumped into looking at the revised San Joaquin Valley plan. So reviewed thousands of pages of groundwater sustainability plans for months. And I think since then, I've learned a lot about how important it is to have good governance and to have community-driven solutions within the context of water rights, within the context of the Sustainable Groundwater Management Act, and really putting forward what the human right to water is supposed to be, so that all Californians have access to safe, clean, and affordable drinking water. So Community Water Center, our mission is to act as a catalyst for community water solutions through organizing, education, and advocacy in California. And our vision is essentially the human right to water. And so our community partners, mostly based in the San Joaquin Valley and the Central Coast, are fundamentally frontline communities who predominantly are from farm-working communities and families who have been huge leaders within the Human Right to Water campaign, which was passed back in 2012. We're now in 2024. We're still seeing depleting groundwater basins. We're still seeing water quality issues and seawater intrusion happening on the coast. But fortunately, we're able to use the tools of Sigma and perhaps outside of Sigma to really elevate why community priorities need to be at the decision-making table, and those leaders need to be able to express their policy recommendations that is informed by their experiences and their everyday lives. So as Dennis mentioned at the top of the introduction, over 1 million Californians are impacted by unsafe drinking water each year. This is a map showing you the public water systems that are out of compliance. And this is a screenshot that I had just taken this week. You can see there's a large cluster throughout the San Joaquin Valley, but also these are issues happening across the state. And as more systems go into compliance, there are other systems that fall out of compliance. And so the State Water Board and local advocates have been really tracking this through the SAFER program and trying to also pair this with how does this work in the context of the Sustainable Groundwater Management Act. And I'll touch on that in the next slide. So as I mentioned, our community partners are from Central Coast and Central Valley, mostly Tulare County and Monterey County and Santa Cruz County. And all of their water for their domestic use comes from groundwater. Sigma lays out that disadvantaged communities, domestic well users, drinking water users, are beneficial users of groundwater. So essentially, their needs need to be considered whenever a groundwater decision or management action is being made. And with using that as kind of the foundation for a lot of our advocacy, we've brought a lot of residents to do advocacy in the legislature, also at the State Water Board, and also meeting with leaders such as Paul, Department of Water Resources, and things like that. So we've been the leader of several bills, and also within the human right to water, we're also pushing for low-income rate assistance. Right now, water is not affordable for most households, and that's across cities and rural areas. And we know that this is an issue, this affordability issue is not just going to go away. And so we've been pushing for a low-income rate assistance program informed by community partners who have been paying a fair portion of their monthly income just to get water. And they have to choose between, am I going to be able to pay my water bill? Am I going to be able to pay rent? That should not be the reality that we're in right now, but that's what's happening. And this is our AGA coalition, and each community partner is listing out the community that they're from and that they represent. These are mostly communities from the Central Valley, and it's a mix of domestic well owners and also households that rely on public water systems that are relying on groundwater. And fundamentally, I think within Sigma I mentioned that, but domestic well owners, groundwater users have water rights. Within the California Water Code and within the California Health and Safety Code, domestic use is prioritized. Domestic use is prioritized for human health and safety. So while domestic well owners, or just groundwater users in general, have groundwater rights, it is extremely difficult to navigate and exercise their right, basically. So for example, they can't, users can't just walk into a court and sue a farmer. You would need a substantial amount of resources and expertise to do that. And unfortunately, even if they did do that, it might lead to a whole adjudication situation debacle of the basin. And oftentimes, that's picking winners and losers, and oftentimes the losers are domestic well owners within the system. I also want to emphasize that, and we kind of talked about this throughout today, but if you have a water right, you have access to water, you have access to power. And so we're thinking of creative solutions of how to break that up and make sure that it is a much more equitable system. The Department of Water Resources released an analysis of who has water rights across the state. They found that 90% of water right holders are white, 79% are men. And I'm tired of it. I think we need a better system. I think everyone agrees we need a better system. And I'm tired of it. Yeah. Okay. Thank you. I guess my last closing thought, and I'm going to pass it on to Natalie next, is we really need fundamental reform and change, and a sense of real urgency. I know I've laid out a lot of problems, but I've also laid out a lot of community-driven solutions of how to do advocacy at the state. We're also expanding our work at the federal level and really building coalitions across the nation to advocate for safe, clean, and affordable water. Beautiful picture. So thank you, and happy to answer questions in the next session.
I'll try to keep my opening statements quick so we can get on to the discussion portion. My name is Natalie. I'm a water policy coordinator with Leadership Council, and I'm also a PhD candidate at UC Irvine. My work is really heavily focused on the implementation of the Sustainable Groundwater Management Act. I've been studying it since not long after it was passed, and I've been going to Groundwater Sustainability Agency meetings since 2017. So I've had a pretty front row seat to the development of groundwater management in the state. Often when we talk about water rights, groundwater can be left out of the conversations. It's very heavily focused on surface water. And to some extent, I completely understand why that is. In the state of California, if you own property, you have the right to pump groundwater that is connected to that property. Obviously, beneficial use regulates that, but essentially that's how it goes. For the San Joaquin Valley, majority of the land is owned by agriculture. So you can imagine that the majority of groundwater in the San Joaquin Valley is being used by agriculture. The Leadership Council has engaged in Sigma since at least 2017. I began working with Leadership Council in 2018. Since then, I have supported in the writing of dozens of letters to both groundwater sustainability agencies and state agencies like Department of Water Resources and the State Water Resource Control Board. Through this work, I've gotten the chance to partner with communities in Merced County, Madera County, Fresno County, Kern County. And the baseline request is pretty straightforward. They're looking for minimum thresholds and measurable objectives that are going to be protective of their domestic wells and small water systems. Unfortunately, the last 5 to 10 years has seen an extremely large number of wells being dewatered, people losing access to water altogether in their homes. 2022, we saw Over 1,000 wells go dry, and last year's rains didn't prevent wells from continuing to go dry either. During this time, we've engaged in SGMA because obviously that is one way that we're looking for the issue of access to groundwater to be addressed. But realistically, SGMA has a pretty far out timeline. Locals have until 2040 to reach sustainability. Most of our communities can't wait until then. So we're at a point where we have to start exploring ways outside of SGMA to try to address some of these problems, because wells haven't stopped being dewatered, in spite of the fact that we're seeing implementation of groundwater sustainability plans. It continues to happen. And not only are wells being dewatered, but there's associated impacts to groundwater quality when water levels drop. And most of the communities we work with are also dealing with the effects of that. Some of the ways that we try to work around, SGMA not necessarily getting to these issues is we've partnered with Community Water Center and Clean Water Action on bills throughout the years, and there have been legislative efforts around well permitting. That's one way that you could potentially get at some of these issues. We had AB 2201 in 2020, AB 1563, but there was also an effort at the state level. Governor Newsom passed an executive order in 2022 around well permitting that would require new wells being permitted to ensure that they were consistent with groundwater sustainability plans. We'll soon see the results of that, but based on local engagement, unfortunately, I don't think we're quite going to reap the benefits that we thought we would get out of that emergency order. So besides legislation, I think it's time to start looking at other laws that we have available to us. We've seen some really positive developments in the use of public trust doctrine for the protection of groundwater. We had in ELF versus the State Water Resources Control Board, we saw that public trust was extended to the extraction of groundwater that adversely impacts navigable waters. And most recently, we actually got exciting news this week in a Sonoma case where the court upheld that in favor of the protection of public trust resources when it comes to well permitting. Besides that, we also have the availability of the reasonable use doctrine. In a lot of the comments letters that we submitted to the state and to GSAs, we cited the reasonable use doctrine when it comes to allocations. So ensuring that allocations that get set locally are actually upholding the reasonable use doctrine, and specifically in making sure that allocations are going to be protective of the groundwater rights of small water systems and domestic wells. And then besides that, the reasonable use doctrine is dynamic. We do actually have the ability to think about it in the local context. The definition of reasonable use can change based on economy, technology, demographics, and hydrologic conditions, the environment, and other societal needs. So I think California is at a moment where we really need to start thinking through what is the actual reasonable use of groundwater in the state, given that people continue to be left without water in their homes. And the passing of SGMA, unfortunately, as of now, hasn't fully prevented that. Again, SGMA has until 2040, right? So we have a pretty long way to go until we get a better sense of how successful SGMA is going to be to addressing some of these issues.
Well, I think we have a number of different things that we could follow up on. I think the first thing I would like to ask, principally to Crystal, is are there key differences or different challenges in addressing the water issue for the tribes between the federally recognized and the non-recognized tribes?
Yeah, I don't think that whether you're federally recognized or not, that it changes the challenges. I think we're just, in general, we're all, extremely, we're just at a disadvantage. And so there are, ways that we, as a federally recognized tribe, ways that we do try to help our other neighboring tribes that don't have that designation. For example, the Wintu, they're up near Shasta. They're a part of our petition effort. And we've just been very fortunate at Shingle Springs where we have some resources that we've been able to dedicate to things like water quality monitoring. We just started a program just this past year in 2023 because we just can't trust the state really to take care of us. And so we were able to get some funding from the tribal council to start our own water quality monitoring program. We're collecting our own data. It's how we knew that in certain watersheds in the areas that we're trying to conduct things like ceremonial and cultural activities, it's how we knew the water wasn't safe for us to put our youth in the water or our elders. If so, an example of that is, we're able to also help our neighboring tribes. We share our data. We let folks know if, based on what we're finding, if the waterway is safe at particular times of the year. And so that's just, one example of how we're trying to help our federally non-recognized tribes.
So when we were putting together Sigma, one of the topics that was discussed but did not get into the final legislation was dispute resolution, both within the GSAs, the groundwater sustainability agencies, and between the groundwater sustainability agency and the folks affected by the plan. DWR's approval of a plan does not necessarily mean that the plan follows the groundwater rights system or not. And in fact, Senator Stern had a bill to make that clear that the state board, DWR's approval of a water plan, a GSP, does not, it should not be considered evidence that the groundwater rights were being protected or not. So within Sigma how would we go about putting together a dispute resolution process that might make sense? And this is for anyone.
Yeah, I'll take a first stab and buy time for the others to formulate better answers. So I think we have, I think the most obvious point is that for it to make sense, you're going to need to have a funding mechanism for the participation of people who aren't already bothered. This is what we do in all kinds of different proceedings where we're very concerned about the equity of the outcomes, and we think we have this big disparities of wealth and power. We have intervenor funding, or we have other mechanisms where we allow basically a group that doesn't have a lot of money but has a very important interest at stake to participate and be compensated for its time. So I think that's an essential element. Then beyond that, there's a variety of, in theory, the Sigma process itself is a dispute resolution process. That's what it's there for. It is supposed to be a forum for the GSA, which ought to be a somewhat democratically functioning entity, to resolve some of the challenges of allocating water in the community. So I think I'll leave it with those two thoughts, and others may chime in, but the process of drafting and approving a GSP should be dispute resolution. That should be embedded in that process rather than something separate.
Yeah, I can just make a quick comment about why community outreach is so important and is a key part of dispute resolution, or being properly compensated for participation in these really complicated Sigma proceedings and decision making. So as I talked about before, drinking water users, domestic oil users, disadvantaged communities are beneficial users listed under Sigma, and also stakeholder engagement is a big priority within Sigma, because we are worried that the status quo would just be repeated again even under this law. So a lot of groundwater sustainability agencies, they have public meetings, they also have advisory committees, so Natalie and I are part of a couple of advisory committees, and there's a lot of agencies that have been very open to talking to community members and community groups. But there are other agencies who don't respond to my emails. So this is the wide spectrum that we're dealing with when we're trying to bring forth community solutions, and we can't even get a phone call. We can't even get a meeting with that staff member. so at that point, that's when we go to the state regulatory agencies and also make sure that those decision makers are meeting with community members as well. And understanding that these broad statewide policies do have really big impacts on what happens when someone's well goes dry, or when their well is also contaminated with several different contaminants. So I think even within that framework of making sure of providing that space to connect community members with state decision makers, with local agency decision makers, those community members should be fully listened to, respected, and have consistent community engagement. It should not just fall on community members, reaching out themselves.
It's interesting that you said that you see Sigma as like a dispute resolution. I think in some ways Sigma was written to not get at that issue. One of the things that Sigma requires you to consider all beneficial uses. Consider. It doesn't prioritize certain users over others, which if you put that in a historical context, it's pretty difficult for small water systems and domestic well owners to try to have to operate under that, right? Because most of them have already probably had their groundwater rights infringed upon realistically. Ideally, they would be the priority in implementing this law, right? Ensuring that people do not lose access to potable use. And realistically, our overdraft is pretty bad, right? So even if like tomorrow agriculture really tightens down on pumping, there's still a really high chance that we'll see wells continue to go dry. So ensuring that you have some kind of emergency measure for that. In order to really get at some of these groundwater rights issues, because that really isn't something that Sigma confronts, right? We're talking about management, not so much really dealing with the fact that there are certain users that as we move towards sustainability will continue to bear the brunt of the decisions that we've made in this state for years now. I go back to the same thing, set protected minimum thresholds and measurable objectives for small water systems and domestic wells. I think it's unfair to have to ask communities to have to do the work of telling others how they should be protected. They should just be a priority.
So I don't want to put words in your mouth, but here I go. So are you suggesting then that it might make sense to amend Sigma to specifically link the policies for sustainability to be consistent with Water Code Section 106, which says that the priority should be domestic first and then agriculture second?
I would say not just link it, but I would say expanding the human right to water, not just to state agencies, but to water districts across the state. Yes.
So we've been talking about human uses mostly. Let's talk a little bit about public trust resources, because I see Michael's here. There's been some talk off and on over the years about giving a water right to nature or to public trust. What are your thoughts about that, and what challenges would doing something like that face?
So, wait, Kyle, AB 828, right? No? No. Okay, just kidding.
So I'll jump in on this first. I think the term would be recognizing. I think it's already, public trust doctrine is already part of California law. Lots of different environmental protections are already part of California and federal law. And so to me the question is not so much, should we give the environmental water right, as should we recognize what is already part of our system of law? And then the question is, well, how do you do that? So at the risk of putting words in your mouth, you said there might be a question about, what would you do if you could have just one law? And there's a long list of things I do, but one on that list might be just to fund the State Water Board and the Department of Fish and Wildlife to actually set quantitative in-stream flow standards, which they have done for some waterways, but they're way behind on where they should be. So to mandate that, but then to fund it, because it's a significant effort. And I think that would be a step towards turning what already, I think, is something our law calls for into a reality.
So you actually, yes, I was going to ask, and now I will. So if you could change one law, state or federal, what would it be? We'll start with this.
Yeah, I mean, the entire existing water rights structure just needs to be restructured, and so I would change those laws. I think, obviously, as I mentioned, the first in time, first in right, then let's really do it justice and take it back to who was here first in time, and have those rights be given back to the tribes. And I say given back, but what I really want to emphasize is that the way that we think about water rights, they're inherent to us, whether or not the state recognizes them or not. But we understand that we have to learn how to navigate within these systems, and so hence our advocacy. I want to share one thing with you. There's a saying in Indian country, and it goes like this: don't cry on the shoulder of the guy who stole your land, right? And so that's just a reminder to us about the structures we're working in. Racism, colonialism, those aren't relics of the past. They are alive and well, even in California, and we have to continue to work within them. We have to continue to advocate. Tears don't do us any good. And so, we now, as tribes, are learning how to be our biggest advocates. And I think, like I said earlier, we're finally getting that needle to move a bit.
Yeah?
Does it have to be water related?
Change traffic laws.
Yeah, I'm not traffic laws. No, I've just been thinking a lot about the equal rights amendment, and I think that, we can go even farther than that, just change the whole California Constitution, even the national Constitution, because I think it's just what happened in 1776 or whatever, is really messing up what's happening now.
So there's a lot of things I would like in Sigma in particular to change, but I think fundamentally there is an issue with tethering a groundwater right to property. At least for Southern California and the San Joaquin Valley, it certainly is. It means that those who own the most property just inherently will have more power and access to that groundwater. I think it would be considered a constitutional taking, but I would untether those rights. I don't think any waters honestly should be privatized, and I certainly don't think groundwater should be. So I would disconnect groundwater right from property rights.
Okay. My mind is spinning right now. I'm trying to figure out how we're doing that and all that stuff. So actually, I want to get back to, so Crystal, you said you would like to restructure the water rights system to address, the various challenges that tribes currently face. Any thought on how we might actually go about doing that, considering that water rights are a property right, and we will have to, at some point, deal with at least the potential for takings issues?
Yeah, I think we have to start by talking to tribes. So many times there are decisions that are made that impact us, and nobody's at the table, and nobody's saying, where are the tribes? And so, as we think about those types of conversations, we have to be a part of it. We have to be in leadership positions. We have to be listened to. And not just for what I say, other opportunities for exploiting tribes and our knowledge, but from a really, truly genuine place. There's this, trend right now with TEK, traditional ecological knowledge. And we're seeing it, state agencies now are throwing that term in, right? TEK, we want tribes to come, we want you to share your knowledge with us. And we're saying, hold on. How are you gonna protect what we share? How are we not going to continue this cycle of, exploiting tribes and extracting what we have, right? And so, it's just, incredibly difficult for me to sit here and tell you, here's how the water right structure should be. We just have to start the conversation, and tribes need to be there.
Let's see how we're doing on time. Okay, so why don't we see if anyone in the audience has questions? We'll start with Michael.
Well, I was just wondering if anyone had thought of the idea of placing reasonable limits on attorney's fees.
I'm sorry?
Attorney's fees.
Oh,
Reasonable limits on attorney's fees.
You mean to make attorney services more affordable to
I mean to put reasonable limits on attorney's fees.
Yeah, I don't think that's responsive to the question.
yeah, I don't
No,
know.
but has anyone suggested that?
Sure. It's not what we're.
I mean, it might make sense if we were talking about putting together a dispute resolution process regarding Sigma issues. I will just comment that, earlier it was suggested that, Sigma ought to be the dispute resolution process and such, but we have some notable examples where that hasn't been the case. Indian Wells is my favorite to watch. I've lost track of how many lawsuits have been filed over there. So it's not just disadvantaged communities and such having issues with various GSAs. It's pretty much if you're a groundwater user, somebody in your class is ticked off at somebody someplace.
I think one thing, and there was, I forget now the bill number passing last year, I think it's something that we want to take into consideration if adjudications get triggered. For the San Joaquin Valley, one of my biggest concerns is that an adjudication gets triggered in one of the basins that I work with community, and how do we support that community through a 10, 12, 15-year courts process. A bill passed last year. It at least allows for the State Water Board and Department of Water Resources to be able to engage in the decision-making of the adjudication, but realistically, it's something that we give a lot of thought to. Adjudications, I'm quite frankly kind of scared of them because of the fact that we just don't know how communities will do in the courts if we get to that position, but certainly is like how can we afford to protect those communities in an adjudication? Like that's a big undertaking.
What about guaranteed legal fees in bankruptcy?
Okay, so we've got other topics we want to move on to. Michael, we've got a question over here.
Yeah, I had a question, and I wanted to say thank you. I really appreciated all the knowledge and comments. The earlier panel, there was a discussion that within the agricultural community, there's a difference between small family farmers who may be part of a disadvantaged community and big ag, all of whom are perhaps drawn from the same groundwater basin. Do you have any reflections on that disparity? And then my second question is, what are your thoughts on something like a fee structure that would be a fee on these big ag type entities that could be used to fund infrastructure or water quality treatment? Maybe a gradated fee structure that
Can you repeat the questions?
exempt certain groups from the fee, whereas a fee might be placed on others that are pumping more because they have larger land ownership.
So the first question was, earlier, there was another groundwater panel, and they talked about the discrepancies between big agricultural corporations versus small farmers, and what are our thoughts on that in terms of the context of this panel? And then the second question was, what are our thoughts on setting fees on certain users, right? Certain agricultural users, and using those fees to fund water quality, monitoring, infrastructure, things like that. I can take the first question. I think there's this, like you said, there's this weird us versus them narrative when it comes to water issues. Our community partners, some of them are small organic farmers on the Central Coast, and so they have a fundamental understanding of what sustainability really means in their basin, and they're also very much interested in learning how they can use that knowledge to advocate in the SGMA process. So I think there's, even in that conversation of small farmers versus big farmers versus disadvantaged communities, there's this recognition that agriculture is a huge part of the culture and identity of the San Joaquin Valley and the Central Coast. And it's how people have built their communities and built their families. So we also are really worried about agricultural corporations taking over. And we've already seen that happen across the Central Valley. And so we're still trying to figure out, like, in the context of SGMA, in the context of human right to water, how can we push for drinking water, even though all these things are also happening at the same time.
So I can take on the fees question. I think the first thing it's important to be aware of is that a lot of GSAs already do this. So we heard Aaron Fukuda talking about this with this GSA earlier. In order to operate, in order to do programs, a lot of GSAs do charge extraction fees and then are taking those fees and using them to fund their governance activities, and then also the kinds of collectively beneficial recharge projects that the last panel was talking about. And it's controversial, it's not easy. Like, they take a lot of heat for imposing those fees sometimes. So this is something that is already being done. So I think the interesting question is, well, what could be done on a larger scale? Could it even be potentially done statewide? I think the answers to those questions are yes. In fact, this is something I wrote a paper about a couple of years ago, advocating for taxation of water consumption. And I think the basic argument is it's a public resource. Right now, we don't generally pay anything for water. We pay for the energy it takes and the delivery infrastructure it takes to get it to us. But in general, our water is, we pay nothing for taking that out of the environment. Economically, that doesn't create great incentives, and it leaves us short of infrastructure funding that we might otherwise need. And then, as with most tax or fee schemes, it's definitely possible to construct exemptions for people who can't afford it. That's something we do in a lot of different policy realms, and I think we could do it here as well.
I'll just plug in a Clean Water Action and Audubon-sponsored bill, AB 828. So on the flip side of fees, being able to use fees to for like local implementation of plans, we also want to make sure that that cost burden doesn't fall on small water systems, disadvantaged communities, and in the case of this bill, wetlands. So the bill is looking for an exemption for those three users.
Could you repeat that?
AB 828.
Way up at the top.
Thanks for the shout out. We're charging our guys a lot, and you have one of the best advocates for the disadvantaged community sitting on your panel. Tian has brought the issues to us, and so we now own those issues. But there's two things I want to state, and I know that this is not going to go over well, so you can boo me as I walk out the door. I hear you on the water rights issues, and you guys want to look at restructuring and reopening them. In one of your statements, you said that money and power flow to the water rights. And you're going to ask to open up the water rights. Do you not think that that money and power is going to ensure that their money and power either continues or grows? So I caution you, as I don't own a water right, other than my own little home which my well's dry, which everybody thinks is ironic. The GSA manager has a dry well. So it's hilarious. I get so much a rash about this, it's funny. But Tian, and I don't know what, I value we're sitting down and talking through these things, and I'm gonna take the water rights that I manage on behalf of a large group, which includes our disadvantaged communities, and start solving problems. Just cautionary note, you are absolutely right. Money and power runs these state governments, federal government, so buyer beware on that issue. The second is, and you presented a neat and interesting scoring criteria for the governance of our GSAs. And you often get worried about these because what I noticed was you evaluated the boards, but Tian pointed it out. The board is the discretionary decision to make the vote, but like in our GSA, we have an elaborate structure below that GSA, so the decisions don't even get to the board unless they've gone through an advisory committee, which includes all beneficial users of groundwater. So we'll sit on an issue for months until we can get a unanimous vote to move that to the board. And that has representations. And we also have a rule within our advisory committee that prevents the larger corporate people that get on our boards, because you have to own the door. The same principle that applies to the board that which you don't like, which doesn't allow you, protects you, because now we won't allow the corporate entity into our advisory committee because you have to own the door for which you represent the seat, right? So you can't be an agricultural entity managing ground in my GSA, but have a farm manager represent you, right?
Wait, Aaron, was that a question or a comment?
It's kind of common. So the question
What
is,
am I doing here?
well, I went to the
What am I
restroom,
doing
there
here?
might have been.
Question and answer.
So the question then is did your scoring criteria evaluate the governance of the entity versus the representation of the entity?
So a quick answer, no. It was a huge amount of labor just to gather the board data. And so, no, I know there are going to be nuances and then personalities and all of that won't be captured there. But the presumption is that boards still matter.
And can I make a quick comment? CEA is really unique, okay? CEA is unique, all GSAs are unique, all basins are unique. So I really do appreciate the working relationship I have. And, Natalie has also been a really good partner in our work in the CEA sub-basin. I also want to recognize, that Tulare Irrigation District has pre-1914 water rights. So that means they have a lot of water, they have a lot of power. Our communities don't have pre-1914 water rights, let alone post-1914 water rights. But I will say that, even within the system of I'm working within the advisory committees and working outside of it, it's still such a big uphill battle just to bring drinking water to the table for a lot of groundwater sustainability agencies. That's not the case for, in the conversations in CEA, but some basins I don't even have a working relationship with them. And that's really disappointing because then they get upset at my letter and I'm like, I tried to talk to you, but you didn't want to talk to me. So here's a really snarky letter to the Department of Water Resources.
In the back with the burgundy shirt.
Yeah, hi. I didn't need that, but thank you, Howard. Name Rangel with American River Outfitter Association. Tian, I found your slides that you had, the one showing, 150 or more, water districts that had substandard water, and then the slide that you had of your coalition. Such a huge difference between the number of folks that are organizations that you're working with in the coalition and how much is out there. And my question is, how are you tackling that difference? How are you getting more representation in your coalition so that you become more powerful than you are?
Mm-hmm. Yeah, so these are not all the members of our coalition. So this is mostly focused on the partners in the San Joaquin Valley. We're doing a lot of work in the Central Coast as well and trying to really connect together the groundwater issues that are happening in Monterey County, in Salinas Valley, they're very similar power structures within the San Joaquin Valley. And I think what's something really important to know about the Central Coast is seawater intrusion, which is basically irreversible. And it's caused by a lot of overpumping of groundwater, and basically seawater comes in. So we have residents who not only have major contaminants that are very harmful to human health and safety, but they're also literally fighting the ocean from getting into their well, which is bonkers. And so we, alongside of building our coalition, we do a lot of partnership work with Leadership Council, who does work in the East Coachella Valley. We also work with Clean Water Action very closely, self-help enterprises, and I kind of alluded to this earlier. We're expanding our federal advocacy as well. And one of our partners is We the People of Detroit, that's working on affordable water low-income rate assistance program across the nation. So happy to talk more about this after.
And for the students here, bonkers is a technical groundwater term.
Kyle? Sure.
Could I just maybe follow up on a quick question and pose it to you, Senator? We talked about how there's a lot of water and power behind water rights, and a lot of that is concentrated. And I think with your bill last year, I thought it was pretty common sense. I guess again, I'm biased. I've been doing this, lobbying for a decade, but there was still an intense pressure there. And so I just wanted to ask maybe if you could describe how that opposition works, and then as we talk about wanting to create a more just, equitable system that takes power away from the few and distributes it to everybody, what are some tips you can give to those of us who are doing that work in order to help overcome that opposition that tends to have form?
Thank you for the question. I mean, while I'm hearing this discussion, I've been thinking exactly along the lines of your question, because the legislature is just in a different place on so many of these issues. I saw your chart, Professor, and you'll notice that my bill was by far the most modest. It only solved one of your 7 problems, and it only partially, I think. And yet, it was amazing how hard it was to get that thing passed. And of course, the other ones that I said to people, I'd rather have those bills passed than mine. Couldn't make it out on the Natural Resources and Water Committee on the Senate side. They did make it out of the Senate, the Assembly floor, so kudos to those authors for getting off the Assembly floor. But you're right, the power structures are difficult to break in this space, and I guess it gets so entrenched. Not only was it ag interests at this time, but you got all these cities who got riled up. So instead of it just being a difficult conversation with those people who represent the Central Valley and the coast, we suddenly had mayors of various cities that were calling in with concern because their water agencies were saying, hey, wait a minute, we don't want anything in any of these bills that are going to mess up our ability to access water and screw up the system, because they have locked-in contracts, and all of the water agencies that were impacted, and land and water rights owners were getting really hopped up, and they just went ballistic. I do think you've worked a lot in Sacramento. You do know that there is always this slippery slope argument that kicks in. It's why the doctors fight like crazy the second the nurses are trying to authorize some tiny little procedure that the nurse will be able to do instead of just having a doctor do it. And it's not that in the end it's going to end medicine, modern medicine as we know it. It's just that the doctors know that if they make it easy for the nurses to be able to do a little more procedure, they'll want another procedure and another procedure. The next thing you know, they're worried about doctors controlling the medical process, right? And so this is what happens here in this space too. And even a relatively modest request. Now, of course, we had to drop a number of things from the bill, and there was issues relating to public, the broader environmental right to water, which we wanted to house in the water board in the case of forfeiture. we had to drop that. I mean, it was amazing how much power these various water agencies have with the legislators. And that's really what this comes down to ultimately. These water agencies and all the different entities involved with water have a lot of power with their legislators. It's either through direct relationships, through their local governments, through the big businesses that employ folks in their districts. And so they are incredibly influential. And it's part of why we can't even get these two bills, the ABs, it's part of why at least we've stalled in getting them out of the water committee on the Senate side. Now, it's not as environmentally friendly as it went back when Dennis was the consultant. And let me say, by the way, we're all very lucky to have this debate moderated by Dennis O'Connor, who's been at the heart of water policy in Sacramento for many, many years, an incredible mind, and someone who's really helped to push the envelope forward in all sorts of ways, but also someone who's got some scars on his back from all these water wars. And so thank you, Dennis, for your service to our state and to trying to make our water system work a little bit better. But it's hard. I think we ultimately have to start to understand these power dynamics. And then it's going to take a systematic political engagement strategy that's going to take a long time. Now, part of why I'm excited is that we've at least started the conversation. I've seen this on a number of environmental issues, including ones that we worked on together, including we did a big plastics bill. Big bill. It's now made international headlines. It's going to really change. We're now going to have an extended producer responsibility system for plastics manufacturers. So they're going to have some skin in the game and some accountability associated with the end use of their products. When we first came out with that bill, it was just a total brick wall of opposition. And we came at it year after year after year. Finally, a ballot measure was qualified. That got their attention on the industry side. That then sparked a negotiation. Finally, we got the most comprehensive plastics waste management bill in the nation done, and it's going to start to move markets, which I'm really proud of. I'm really excited about. But it took years, and it really took a long time for the members, the legislators, to get acculturated and educated and understanding that there was a problem. Because when you first put these things forward, I think what's happened in the past is people say, oh, water rights is just too hard to deal with, don't put a bill for it, you're going to get hammered. And it's true, you get hammered. The downside of not putting bills forward is that the conversation doesn't happen, and then your colleagues don't even know there's a problem. They're just kind of keeping their heads in the proverbial sand, right? And just keep, because in the end of the day, they don't want problems, they don't want drama from their local industries, they don't want drama from their local agencies. With these bills, we've now forced a conversation. I just think we have to keep coming at them and keep bringing up these issues. And we need to start thinking about ways of building power in communities. I think it's, the EJ community has certainly gained a lot more traction than they had when I first got elected to the Senate, which was only 9 years ago, 10 years ago. Not that long ago. They really weren't anywhere close to the kind of presence that they are now. So that's a good thing. They're starting to play and starting to engage and starting to, make sure that their priorities are rising to higher up on the radar screen. But I just think that that we need to figure out more strategies of really getting onto legislative radar screens and really trying to build power. I know Christina Boss Hamilton just wrote a book. I haven't read the book yet, so I don't even know why I'm recommending it. But let me say, I ran into her the other night at a party. She just come from a book signing. She wrote this book called Changemaker. And she wrote it because she saw all of these working class people, the organizations would bring them up, they'd pull them out of work for the day, which of course is very difficult for anyone to do, certainly someone who's working class, spend the day in Sacramento trying to advocate for a bill, and then the bill wouldn't even be heard in committee. I mean, there just wasn't a strategy, they weren't. So she wrote this whole book of trying to help regular folks understand the processes of Sacramento so that they can access the system just as well as people who pay a lot of money for high-paid lobbyists. Apparently a bunch of lobbyists really mad at her for opening the magic book. So I just throw that out there to say, read the book, let's learn more about, it's ultimately about building power, finding ways to get to legislators on their own home turf, engaging in political campaigns more effectively and tactically, engaging in members' districts more effectively and tactically, and engaging with people who got money, certainly, but recognizing that there are also other ways to gain access to power. It's not just through money. And there are all sorts of groups that have found ways to do it, and they just have to do it differently. I think about Jennifer Fearing, for example, who many of us have worked with. She doesn't raise any money for legislators, and yet she's gotten all sorts of bills through, environmental lobbyists. You just have to press the levers differently. And that's what we have to do here.
Why is Donald Trump running for president?
So we
I
won't,
mean,
so we won't go to jail.
Climate change.
Okay, let me jump in here. Just one quick thing for Kyle. As a person who staffed a whole lot of these bills as Senator Allen said, people don't realize that Sigma didn't come out of just poof in the air. There was a lot of legislative work done before that. Senator Patley carried a bill that required all basins to be just monitored for elevation. That bill took 3 tries to get that through. We had a bill to try and make well logs public. That liberal state Wyoming says that before you drill a well, talk to your neighbors and get copies of their well logs before you start drilling. California, that was confidential information. That was another bill that took 4 years to get passed. But by carrying these seemingly small bills, you start creating the knowledge base necessary for members to be able to put the issue in context. So that's just a section. We had a question over here.
Hi, my name is Jack. I'm an undergrad at Davis. This question is mainly for Tien, actually, because we have an interview in a couple weeks, and I'll try and impress you with it. But also anyone is welcome to answer. So everyone's discussed water rights and the issue of lack of water in wells in the Central Valley, but at the same time, contaminated water in groundwater and stained wells. You had white dudes in the late 1880s recklessly diverting water from the Colorado River that creates the salty sea. That's creating salination issues with contaminated water. You've got big farms that are trying to put out mass products that are overwatering, using pesticides, contributing to eutrophication and polluted runoff.
What's the question?
I'll get there.
We need to get there sooner though.
Is there a significant relationship between those that contaminate the water and those that overuse the water? If so, how does your work look at that?
So the interplay between over pumping of groundwater and groundwater quality. So Aaron kind of mentioned this and we've kind of touched upon this, but when you over pump groundwater, it can cause contaminants to move around and also potentially move closer to shallow wells and contaminate that well, so that water is no longer safe for basic domestic use and also definitely not safe to drink. So we talk about that nexus a lot, especially because within the San Joaquin Valley and Salinas Valley, with agricultural businesses, we have pesticides, fertilizers, PFAS, just a whole slew of different contaminants that are really harmful to humans, harmful to the environment, and yet we still keep using them and we still keep applying them every day so that we can make money. Sorry, that's a really curt answer. But sometimes there's a lot of questions around what is the GSA or the Groundwater Sustainability Agency's responsibility in terms of groundwater quality? And what is their role in the context of, we already have management zones for salinity, for nitrates, where does the Groundwater Sustainability Agency come in? Where does also the Department of Water Resources come in? So ultimately, Sigma is trying to put together, all those different bad outcomes and trying to make it so that you're relating over pumping to groundwater quality. So there's a need to monitor not just groundwater levels, but groundwater quality across the state. And recognizing, are your pumping practices exacerbating that water quality issue? And so we've been working with a lot of GSAs on this to make sure that it is a big priority and that they do have the proper monitoring networks to make sure that people that rely on drinking water for their domestic use are not drinking contaminated water.
Let's go to Andy.
Your chart, Dennis, as I recall, did not include AB 1272, Assemblyman Wood's bill to provide for drought or water shortage response planning that would have facilitated protecting in-stream flows. As you know, that bill was enrolled and withdrawn from enrollment under threat from the governor's office. Do you see a potential that either that bill or some other bill will go forward this year to provide for protection of in-stream flows?
Well, okay, the veto statement said, as I recall, something about this is frickin' expensive.
It wasn't a veto, it was a threat of veto.
Or a threat of veto.
Yes.
But in prior versions of the bill, that was
Yes,
the stuff.
and it was amended to take out the.
Right, just looking at the LAO's review of the budget and all that stuff, I don't see a whole lot of money lying around this year to fund stuff. So I would suspect that a major, any bill that is going to require, pretty much any additional staffing or effort, is not likely to get chaptered this year. I mean, certainly there are going to be things that the governor is pushing, and those things will, but pretty much nothing else will. I don't think. Just reading between the lines in the LAO report. Oh, I just used my degree. It's in economics, so you wouldn't know it, but I so rarely get to use it working in water, but there you go. So it seems unlikely this year, to me.
My name is Celine. I am a first year at UC Law. Just some statistics. 142 million gallons of water a day are used to produce dairy in California. I'm wondering why the differentiation of different kinds of industry are not being mentioned in this conversation. How are we going to empower the communities to be aware of where our water is really going? Commonly, people will say, oh, the almonds. For reference, almonds in 1 year will be like 1.6 million gallons. So I'm wondering, where's this discrepancy in the discourse? How can we bring this up? This is important. Is it a human right to access water, or is it a human right to drink milk from a cow? Any comments?
So I think it's a good question. One thing I will flag at the outset is that people who grow alfalfa will point out that it is a fallible crop. It's not perennial. And so there are some advantages to crops like that in that relative to, trees that have to be watered every year. So as a portfolio of crops, having some crops that you can fallow is not a bad thing. I think the catch then is, then you have the enormous inefficiencies of growing crops as animal feed to then feed us. Like you could have other crops that are the fallible options that wouldn't necessarily need to be alfalfa. So I'm going to try to answer your question, why, without trying to justify it. I think the basic reason is that traditionally we treated all agricultural uses as beneficial uses. To have a water right in California, or an appropriate right, it has to be a beneficial use of water. And so we just categorically treat agriculture as a beneficial use. And then the use also has to be reasonable. And reasonable use doctrine in California is it's still something of a sleeping giant. It is something that it's rarely used in litigation. In state water board proceedings, increasingly the state water board is using it to do things like impose urban water use efficiency requirements, and also as a potential basis for in-stream flow requirements and for drought response. But nobody has yet had the ambition to do something as big as what you are proposing, which is to say, look, there's just this category of uses that is exceedingly inefficient, even though it is very traditional. So maybe someday you will litigate that case.
Yeah, but in the meantime, I think it's important to have these conversations and bring this up, and it is such an actionable thing that we can do as consumers with our dollars. Don't give them to those industries that are using all of our water.
Yeah, though of course,
It's really Supreme Court.
if we
Decided to get rid of the reasonable standard. Now that was something. Like,
yeah.
So, no, that's not happening.
So Senator, why don't you finish your question and then you get your response panel.
Okay, all right. Well, I would say, you said you're starting, you're one outlander, right? Okay, so here we are in the law school, professor knows this as well. So, we are both blessed and cursed, as with the inheritance of the common law, the English common law, which has served us well in many respects and not in others. If you've ever spent any time in the UK, one thing they have a lot of is rain. The common law also was developed at a time when there were far fewer people. And the whole idea of reasonable beneficial use is based on a very different type of climate and very different amounts of water. And of course, they've just been plopped onto a very different climate here in California. Now, interestingly, we actually, much legislative, we took a trip to Australia, which is also a common law country, very much rooted in British legal heritage. Australia has similar climate to ours. They had to undergo a very ambitious and fundamental change to their water system because it was breaking. The southeast corner of the country is where basically everybody lives, and there just wasn't enough water for everybody, less than we have, in fact. And they created a whole new system where now there's full transparency. You can literally download an app right now, and you'll know exactly what every reservoir, lake, river level in all Southeast Australia is at any given moment. There is a certain amount, so you know exactly how much water is available. They allocate a certain amount of water per person for personal use for the region. And then the rest of the water is open commodities market. And so when there's more water, the price of water goes down. And when there's less water, it goes down. When there's less water, the price of water goes up. And it really does price into the market and the cost of water, and those crops that are more water efficient end up being more economical to produce in the area than those crops that aren't. And by all accounts, it's worked pretty well. Transparent, open market, and they've created some mechanisms to protect against market manipulation and some investors coming and screwing things up. Now, that of course was a very difficult thing to do, but they were able to do it. Here in California, we've got all these political powers that be that have just made it incredibly difficult even to make even the smallest changes to law. And it's, I think, at the heart of Kyle's question. Now, that being said, I think of other areas of law where a lot of shibboleths have been torn down. Some for better or for worse. My good friend Debbie Segura is here, is a local government official from my district. And one of the conversations that we often have, certainly I have a lot with my elected officials in my district, are concerns about, the state has certainly taken a big, heavy step into housing policy, and things that 10 years ago I never would have imagined that we'd be doing. The state has really stepped in and kind of totally taken local rights and shaken them up pretty aggressively. Cities used to have plenary power over zoning and all sorts of questions relating to the way that they allowed for housing, and that's really been called into question in a very serious way. Folks said, hey, we have a crisis on our hands, we need more housing, we're just going to step in aggressively. Some of the bills I think have been a little heavy-handed, too much, but I also get the momentum and I get the reason behind this. And I throw that out there to say that necessity created aggressive action, a lot of pushback from the locals, and yet ultimately the Sacramento overrode that pushback. Now, in this case, in that case you had an interesting combination of power and money kind of stomping on the cities. I think this is going to be harder because you've got a lot of vested power interests and money interests that will be pushing back on this kind of thing. But I put it out I throw it out there to make the point that sometimes the shibboleths, when we all stand around and say, oh, nothing can ever be done, it's not necessarily the case. All sorts of things have shifted. in state government, things that even in my 10 years in the legislature, when I first got there, they said, oh, you can never do anything in that space. Well, now bills have passed that I would have been unheard of even 10 years ago. So I throw that out there to perhaps provide a little bit of inspiration that maybe we can start thinking more boldly and more aggressively and get more relentless and just push, because the situation demands it. Given how out of whack our water rights system is, with just the basic amount of water that we have, let alone all these equity issues that we've talked about here. Getting back to the question that Kyle asked, your question about power and access to power must kind of undergird the reason why Professor Owen's trying to get more democratically elected boards to run the water system. So that at least you can send constituents to these boards to ask them, to question their opposition to all of these good water bills in Sacramento, and push back and get engaged in trying to elect different people to these boards, perhaps. Same thing with city councils. I was surprised that very progressive cities were coming out opposed to these water bills because they were getting spooked by their suppliers. And who were kind of raising red flags about, you're going to break our water system, and we're not going to have any water for your town if these water bills get passed. Of course, all these water bills we're trying to do is make sure that the water board can actually better manage the system, so there will be more water available for everybody in a more sustainable way, as opposed to centralizing it in a lot of these vested interests. But I would say, let's talk about who those cities were. Let's get activists to those city councils. I think some of those city councils would be shocked if they knew the positions and the roles that their cities were playing in helping to defeat progressive water legislation.
Has anybody read the Magna Carta?
Yes, it's a great piece of literature. So, and the final thing I'll say, there's a great copy of it at the National Archives. The final thing I'll say is, this is another little piece of insight I want to throw out there. There was a lot of mistrust amongst my colleagues as to the water board. They see them, and I deal with this all the time in the environmental space, because we're typically trying to empower various agencies to do better work, to be able to impose good environmental regulations. And this is a constant problem I have, whether it was with our plastics bill. Can Cal Recycle handle this? Are they up to the task? Do we trust them? Do they know what they're doing? Similar things with, we're going to hear from the chair of the air board. They're under constant attack for all sorts of good and bad reasons. The water board also is deeply mistrusted by a lot of powerful people. I also think there's a sense that that their staff sometimes acts with arrogance and not kind of being kind of reasonable enough with regular folks. I can't speak to the veracity of that one way or another, but there were constant horror stories thrown at me about, there's some guy in my district that they came in and just read on the Riot Act and they were so unreasonable and I don't want to give them any more power. So there is a bit of there's an interesting perception out there among some of the politicals that mistrust the agency. And that's another factor that we're competing with here. And maybe that's why we need to have our agency staff read the Magna Carta.
And a constitution. California has a constitution too.
So anyway, with that, I saw you shaking your head a couple times. What do you want to ask?
Oh my gosh, so many things.
Okay.
You're hitting the nail on the head. So what if the Stakeholder Advisory Committee, the SHAC, for the Baina-Giuse has been sued by Aqua Alliance, so is the Butte and Calusa Subbasin, so they removed the environmental representative from the SHAC. How do we deal with this in a dispute resolution issue if it's retaliation? You're asking us to be advocates, and the people who are experts in water on Aqua Alliance are being booted from the SHAC. How do we deal with that in a new Tuscan water district just got formed by, guess what, landowners? What do you do?
Yeah, well, I guess it does speak to the democratic governance questions. I don't know the specific of the situation. Maybe, and I'm sure Dennis is mad at me for letting you ask a question. But now this question is so specific, he's extra mad at me. But it looks like Professor Owen's got a good answer ready. Do you know?
Okay, talk to Department of Water Resources and State Water Board.
Department of Water Resources is the one who advocated for the formation of the Tuscan Water District.
In terms of public outreach and their guidance documents and how to form actually democratic governing bodies, they release guidelines on that. And For example, we, as drinking water advocates, have pushed a lot on how to have stronger drinking water protections in their guidelines. So I can give you Paul's email if you want.
Oh, I have Paul's email, he used to work for Butte County Water Conservation.
Well, we were gonna close with everyone getting a shot to make one final comment, but I think my final comment is catch us as we're walking over to lunch. Thank you.